Ariana, can you give me a call, please? Are you on? There you are.
There you are. Yeah, of course. I'll give you a call. I have court this morning, but definitely give you a call today.
Do we have a hearing this morning in this court?
Not with you.
The docket shows that we do. I had shown that my case wasn't coming up till next week on the 17th, but when I checked the portal.
Oh, shoot. So, well, let me check. I don't have it on my calendar either.
I checked the court's portal and it showed that it was set for today.
Estella, did we have something for today?
Yes, it's the very first one, 2016, DCL 4139.
Okay.
I'd had it for next week for some reason, but can you confirm that those taxes have been paid?
I can check right now. Give me just 5 minutes on that.
Okay.
Richard, I have it for next week too. I had it for the 17th for some reason. That's where I'm pulling it up and I have it on the calendar. I don't see any payments. This is the one, if I'm not mistaken, the one that you received through forfeiture or something like that.
That's right. That's right. And I show that it was, or
we'll double check. We'll call you. I just still see those taxes. I still see them pending. I don't see any payments, but we'll double check. We'll call your office this afternoon.
okay, they were funded on the 31st, I believe, of January. I went to the website and it shows.
And it shows.
Yeah, to the Cameron County Tax Office.
Okay, it might be that we just haven't, it hasn't posted with us. We'll double check. We'll give you a call on that.
Okay, can we ask?
Yeah, for our recent, Mrs. Stella, I had it for the 19th for some reason. I apologize.
Yeah, I know it's set for today. Well, I can go ahead and reset it if that's what y'all want.
Yes, Mrs. Stella, it looks, well, according to Mr. Nunez, payment has been made and we're just not reflecting that at this moment. So we do need some time just to see if the payment did go through or what the issue is.
Next week on that 17th would be fine, Estella.
Can we do the 16th?
Yeah, that's fine too.
The 16th is fine as well.
Okay, I'll put you down for the 16th.
Okay, thank you.
Thank you, ma'am.
You're welcome.
Thanks, Ariana.
No, thank you, Richard.
Good morning, everyone.
Morning, Judge.
357 District Court will call its court into session for today, Thursday, February 10th, 2022 at 8 o'clock. Starting with 2016 DCL 4139 Cameron County versus Nunez. Mr. Nunez,
That one has been reset, Judge. Till February 16th.
2021 DCL 457 Cameron County versus Neida Gomez Gonzalez.
Yes, good morning, Your Honor. Ariana Priel on behalf of the plaintiffs on this case. We're ready to proceed.
All right, proceed.
Thank you, Your Honor. I don't see Ms. Eneida Gomez Gonzalez or anybody else on the Zoom hearing. She has not filed an answer as of today before this court. However, she has been served, Your Honor, and that was personal service back on August the 3rd of 2021. At this time, plaintiffs are asking the court to take judicial notice of all the documents in the court's file. We are asking that judgment be granted in an amount of $2,633.45. We brought this suit on behalf of Cameron County for delinquent taxes owing on the property. Ms. Eneida Gomez Gonzalez, as previously mentioned, was served, Your Honor. And at this time, we are offering Exhibits A, B, and C. Exhibit A is a certified copy of the delinquent taxes for the county. Exhibit B is an affidavit of fees, and Exhibit C is an affidavit of non-military status. We're asking that judgment be granted.
Is this a homestead?
No, Your Honor, this is not a homestead.
Okay. Court will take judicial notice of all documents and file. The court will admit Exhibits A, B, and C. Without objection, the court having called out the name of Eneida Gomez Gonzalez, no answer has been had. The court hereby grants that summary judgment is prayed for.
Thank you, Your Honor.
2021 DCL 967 Cameron County versus Doyle Clark.
Good morning, Your Honor. Ariana Priel on behalf of the plaintiffs on this case. On this one, we are asking that a non-suit be granted. Everything was paid.
Okay. Believe that's it, right?
Yes, Your Honor, I believe that is it. It's great seeing you. If I could be excused, Your Honor.
Yes. Have a good
Thank
day.
you, Your Honor. You too.
See you again. Take care. All right. Let me get to 2021 DCL 6210. I have a whole bunch of filing, Mr. Saguirre, that you filed last night, and there's just no way this court can go through all of this before I come on this morning. I've tried to do the best I can.
I apologize, Your Honor. I should have filed it earlier this week. I got swamped here at the office.
Yeah, no, I understand, but it's just I'd like to read stuff before I get on the hearing, because I did have an opportunity to read your brief in support of Novation, along with a case of Ginther Davis Center's Houston National Bank. After having done so, the court's view of this case is that it's not exactly what's going on here. It's not on all fours, although it does involve, default and what have you. But I am taking the only issue, Mr. Nunez, so you'll know here, is that and the only thing that I think that you can possibly prevail on a temporary injunction, if you give me the proper proof, is what the court said in dicta there. And I believe on page 8 of the opinion, where the court talks about in the last paragraph on page 8, where the sentence starts, although an accountant may ultimately become necessary in order to determine the exact amount appellants owe the bank, that is the only basis I could see granting you a temporary injunction. Because other than that, Mr. Izaguirre makes a forceful presentation about the debt and your novation and your ratification after the mediated settlement agreement. So discussion about what happened in the mediated settlement agreement, what happened in the original note is irrelevant. We need to look at what happened as a result of your negotiation with the mediated settlement agreement and what subsequently was drawn up to govern the conduct of the parties. The fact of the insurance, there was an obligation on you to provide insurance. I think the last time we had this hearing, you were not able to demonstrate that your client actually got any kind of insurance. So basically, all of the expenses for insurance, whether it's the right insurance or the wrong insurance, is being tagged to his account and being paid out of the pocket of the lender. The taxes have not been paid. Then they also are coming out of the pocket of the lender. And the fact of the matter is that this case and all the other cases on equity stands for the proposition that, you may have a legitimate dispute about the balance owed, but to continue to ignore other obligations that are pretty clear, pretty succinct, is in and of itself a default. So what is your response to that?
Judge, for the record, my client has paid the 2021 taxes. He's paid every single principal and interest payment that was due during the life of the note. The insurance was an issue. My client has not maintained insurance. There was only liability insurance that was required. And the reason is we've got property with a fair market value of $425,000.
I understand all of that. I understand that you're saying, look, we only owe him $40,000. The property is worth $9 million. I understand that. But we're digressing from the issue. The issue is, has he complied with paying off of $40,000? And he has no insurance. He paid his taxes for this past year, but before that, he had not paid them. And he continued not to pay any insurance. Do you still have an accounting issue?
We do, and the accounting issue is very clear. My exhibits showed that there were 2 notices that were sent. There's a gross contradiction between one notice and the next. The September 9th notice shows a balance of $54,000. We have a subsequent notice that has a balance of $40,523. The notices that the lender sent out are contradictory. The more recent balance is lower than the previous month's balance without any payment on the part of my client. There's an issue there with how much is owed. For example.
Okay, well, if you ferret through that issue, is your client prepared to pay whatever is owed?
Yes.
Well,
he would need to get financing, but he is certainly prepared.
That's a problem, Mr. This is
It's not a long-term issue, Judge.
It's what the problem is. You're asking for more time for him to go get funding, and that's not the way it works, Mr. Luna.
Well,
I'm asking today.
It's not the way it works.
Where the amount is, can he go over into Adelante Fund and here's your money?
Neither does it work, Your Honor, that the lender says, you know what, you owe us somewhere between $54,000 and $40,500.
I agree with you.
It's right in there.
That's the only thing I may agree with you on, and that's why I pointed out to that section of that paragraph of the case of Ginter Davis, so that I say, yeah, if there's any possibility for me, anything that can be grounded on an equitable basis to issue a temporary injunction, it would be that. I thought the last time we talked, we were on the screen that on Zoom, that both of you, Mr. Zaguirre, had said, I'm going to give him everything he needs to look at the amount that we have, what the explanation is for that notice and the difference between the 54,000 you got in September and the 40,000 you got later on. I don't know if that happened. You were to exchange, Mr. Zaguirre was to provide you documentation. I don't know if that occurred or not, but that's where I remember being left at the last time, and we set it for 2 weeks to be able to review those documents. Did that happen?
I received yesterday the insurance documentation that I needed. So I confirmed that the monthly premium is the amount of $94 a month. But Judge, we've got a September 8th, 2021 notice setting out specifically the amounts that are due. In that notice requirement, it shows that insurance that is owed is the amount of $1,132.68. And yet, yesterday's receipt of the premiums show that it's $94 for the life of the loan. A difference there.
No, Your Honor, that's incorrect.
Maybe
Well,
I'm
the
wrong.
amount of
but
insurance,
I read
the amount of
that's a monthly charge.
right? But they give a September notice that it's $1,100. Now they're saying it's $4,869.
Your
Not
Honor,
a significant difference.
can I respond briefly?
Yes.
Because we're chasing our tails here. A lot of what Mr. Nunez says, I understand he's trying to do his job, but it's totally irrelevant. I apologize again for filing that brief yesterday. I should have filed it earlier in the week. But the brief concerning confusion as to debt balance, which I filed yesterday, talks about this. And by the way, Your Honor, as far as the accounting goes, there shouldn't be any confusion at all. On February 2nd, I sent this court a letter brief clearly explaining the accounting and clearly explaining the absolute principal balance of this loan. There is no confusion about that. I sent almost an identical letter to Mr. Nunez. I believe it was on the 2nd also. In any event, that letter to Mr. Nunez is a new exhibit that I also filed yesterday. It's exhibit D14. And by the way, I would ask that exhibits D11 through D14 be admitted into evidence. I don't have any objection to the two exhibits that Mr. Nunez filed yesterday either. But getting back to the point, Your Honor, Ginther Davis is one of two cases that I cited in the brief that I filed yesterday. And the reason I cited them is it doesn't matter if there's confusion about the amount owed. There isn't any in this case. I assure you there's no question about what the balance owed is in this case. But even if there was, that paragraph that Your Honor cited earlier that begins, although an accounting may ultimately become necessary in order to determine the exact amount appellants owe to the bank, the very last sentence of that paragraph says, however, the testimony on that issue was disputed and the appellants claimed confusion concerning the amount of the payment required to avoid foreclosure. That is not in itself grounds for an injunction, as the bank specified in its letters of November 14th, the exact amount it claimed was due, and the appellants have failed to tender that amount. Okay.
I did read that, Mr. Seguede, but that court and the decision that court rendered in Ginther was based on evidentiary contradictions, evidentiary, basically what the debtors in that case were kept getting deeper and deeper into the hole. You know, they have $5 million loan, and then they asked for another $500,000, which was supposed to be to address the part of the default on the first loan, the $5 million loan, plus interest that was due on that loan, and plus interest. Then he got in trouble with the interest that was due on a $500,000 loan, and
right,
so forth and so on. But we don't have that here. It's not that complicated. It's just straight up transaction. I think the court, under this set of facts, could be empowered to issue a temporary injunction, but I need to hear, you say you've explained that in this debtor thing. Does it explain the difference between what Mr. Nunez is complaining about, that in September you issued a notice that he owed $54,000, and subsequently you issued a notice that he owed $40,000? Where is the disconnect between the amount that you first noticed him that it was, the balance was owed was 50-something thousand, and then subsequently when he got a second notice that said, no, your balance is 40,000? How is that explained away? Just give me a brief understanding of that.
Mr. Nunez is confused about what the demand letters actually say. The demand letters say the correct amounts. Mr. Nunez is reading them incorrectly. And Your Honor, I've been doing collection work for 15 years.
I can see by your writing, you're well versed in this, Mr. Zaguirre. There's no doubt about that.
I mean,
So what exhibit, Mr. Nunez, what exhibit would reflect, or you, Mr. Zaguirre, the notice issued that talks about your balance is 54,000, and then subsequently the balance is 40,000. What exhibits that you have, so I can look at it myself?
They're my exhibits, Your Honor. It's Exhibit C. My Exhibit C shows that it's an October 8th, 2021 letter. And it says this, I'll read the sentence. It's the second to the last paragraph on the first page. The amount on this indebtedness as of October 8th, 2021 is $40,723.98 plus attorney's fees and expenses. Then there is the conflicting Exhibit F, which is the previous month's notice that claims that, and it itemizes 4 past due installments of $1345.93. Ad valorem taxes 7664.63. Insurance premiums, that's the top of the second page. Immediate reimbursement of insurance premiums in the amount of $1,132.68. Unpaid principal and interest of $40,523.88, and attorney's fees of $440. The aggregate, the total of those amounts is $54,704.91.
I don't have that exhibit here in my hand, but for the sake of argument, I'll accept that it's been the case, Mr. Zaguirre. So let me see if I understand what you're saying, Mr. Zaguirre. You're saying the principal amount of the debt is $40,000.
Más o menos, Your Honor.
And the fact that he hasn't paid interest, that he hasn't paid taxes, is irrelevant to the underlying debt. The underlying debt is $40,000, and that's in default.
That's right, Your Honor.
And the rest of it is gravy, so to speak, because in addition to the default of the principal amount of whatever it was, 40,000, he has not complied with other provisions that require him to pay the taxes, require him to pay the insurance, and those are added on. But the principal amount as of that day, as of September, was in default.
Yes, there was.
You had accelerated that some time ago.
The note matured back in 2018, Your Honor, on its own terms. It was never accelerated.
So what's the response to that? As you know, that is a proper approach to analyzing this. If the principal amounts in default, it doesn't matter what the collateral ones are. They may be in default, but they can use the principal amount default to proceed forward to a foreclosure, can't they, Mr. Nunez?
I agree, but when you ask the debtor to cure the default by paying an amount, and you ask in September for the total amount of 40,000, I'm sorry, you ask in September the total amount of $54,704, and then you send a second notice a month later, and you are then demanding the amount of $40,700. There is disparity there, $14,000.
$40,000. It would be in a heck of a hole, wouldn't he?
Because Your Honor, can I say something?
The amount that was demanded in the second notice.
Your Honor, can I say something?
Yes.
Because Mr. Nunez is way off base here, and I'm not saying he's doing it on purpose, but he's misleading the court. That letter that he just showed you, the September 8th demand letter, where does it say $54,000 in there?
Oh, I did the math myself, and
yes,
you can do your own math. But I'm telling you that if you add,
Mr. Nunez, you talked for about 5 minutes and I didn't say a word. Can I finish?
Go ahead.
The amount currently due is $40,523.88 on September 8th, 2021. Okay, Mr. Nunez, on top of that, is adding these other figures. These other figures, the 4 past due installments of $1345, the immediate reimbursement of insurance premiums of $1132, those are included in the $40,523. Those are incorporated into that $40,000 figure. Those are not on top of. You don't add those to the $40,000. Those are included in the $40,000. The total amount is $40,000, not this 54. Your Honor, you will not see the number $54,000 anywhere in this demand letter.
I think the court needs to read that September 8th letter.
Let me take a quick break. Let me find that because
It's exhibit F.
Okay, yeah, I'm trying to find your exhibit list. I've got Mr. Zaguirre's. Do you have any objection to defendant's second amended exhibit list that's reflected and served on you? Do you have any objection to any of the exhibits that go all the way from exhibit 1 to 14?
No, I believe that we stipulated to the
Okay.
admission of those previous.
Those will be admitted, Mr. Zaguirre.
Thank you, Your Honor. For the record, that was D11 through D14.
The ones that I just talked about, I'm talking about your second amended exhibit list that costs from D1 to D14.
Yes, Your Honor.
Yes, those are all admitted. Now, let me find your, I can't find your exhibit list, Mr. Nunez. I know it's here somewhere.
It was filed back on the 1st of November.
Salas, can you help me out, or Miss?
Yes, that's what I'm doing, Judge.
Let me give me a second. Let me find that one.
What was that file, Mr. Nunez?
On the 1st of November.
Okay. And we're talking about an exhibit list, right?
Yes,
On November? I don't
Yeah.
see one.
I'm looking at my final copy. It's I've got a filing number.
Oh, okay, they're over here on top. Let's see.
It says plaintiff's exhibit list for hearing to be held on November 16th, 2021.
I have the first, November 1st, I have the petition documents, the citation, the verification, order setting, temporary orders, precept, bond, affidavit. No, I don't see it.
The petition was filed also on November the 1st. I've got a
Could it be with the petition itself?
let me see. I think it might be the same. No, it's numbered differently.
Is it?
Yes. Oh, I'm sorry. Estella,
Uh-huh.
it was filed on November the 15th.
Okay, November
Sorry.
15th. Okay, plaintiff's exhibit list for hearing be held on November 16th, right?
Yes, and the
That
judge is
one?
looking, yes, that's the one. And the judge is looking for exhibit C and exhibit F.
That was exhibit, Mr. Nunez, exhibit D?
C is in Charlie
Uh-huh,
and F is in Frank.
okay, C and F. Nomás C. Good morning, 357.
All right, Mr. Aguirre,
Yes, sir.
uh, your 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 September 8th letter. You
Yes, sir.
you maintain that the amounts of $7,000. I'm looking at the letter dated of September the 8th. You maintain in your notice and demand for payment. Why didn't you just demand $40,000 as being a total balance owed, including expenses, costs, fees, and all that, and you segregated all those, and then in addition to that, you added a last one that said and $440 in current attorney's fees. Why did you segregate that in such a
So-
way that you just not make demand this total due is $40,523, which represents the principal balance and all expenses, costs, and attorney fees accumulated to date? Why was it not worded that way?
Your Honor, if I knew the universe was going to unfold this way, I might have.
Well, I know that we always worry about that universe. We hope that we're addressing whatever's out there in the universe. I understand that.
But Your Honor, we do prepare for that kind of contingency in this letter. If you go down a couple paragraphs, it says, you may contact me at the firm's address to obtain a complete statement of these amounts. So what ends up happening, Judge, is you send out a letter like this and interest accrues on a daily basis. The per diem interest on this particular note at $40,000 was about $6.75. So interest is accruing on a daily basis, and the debtor is not going to receive this letter on September 8th. It's going out by certified mail. It's going to take a few days to get there. So in the interim, the interest has increased by $6.75 más o menos per day until the debtor gets it. And then the debtor's not going to call you right away. The debtor's going to call you a few days later. So that's why you have this paragraph that says you can contact me to obtain a complete statement of these amounts. And any kind of confusion or doubts about the true amount that's owed are cleared up when the debtor calls. And so if I'm the attorney and I send a letter, the debtor calls me, hey, what's the status? How can I avoid foreclosure? Hold on, Mr. Ozuna, I'll call you back in 15 minutes. Let me call my client and get a payoff. So the bank or the lender will then send me a written payoff statement. And that payoff statement is good for, it can be good for a week. It can be good for 2 weeks. It's good for whatever the bank says it's good for. So Mr. Ozuna, I call him back and tell him, okay, here's the exact amount that's owed. And it's
I
good.
read that part that they were invited to call and find out exactly what was owed. I read that.
Okay,
But I'm going back to what your assertion was earlier, that the 40,523 unpaid principal and all accrued interest due was the total amount, including all the other amounts of 1,132 for the reimbursement of premiums and the 7,000 and something charged for ad valorem tax and the 1,300 for past due installments. And then after each item, you make a separate demand. You say, demand is hereby made for, you want 4 different installment payments that were not paid in the amount of 1,000. That's a demand. You've demanded immediate reimbursement for $7,000 for the ad valorem taxes. You have demanded immediate reimbursement for the insurance premiums in a 1,000, and you have demanded immediate payment of the unpaid and all unpaid accrued interest. Those are 3 separate demands and 3 separate amounts.
except
I mean, the way a little reading of this letter to an untrained mind would say, well, I need to come up with 1,000, I need to come up with 7, and I need to come up with another 1,000, and I need to come up with 40,000, because you're demanding immediate payment of those amounts separately. If I came up, okay, I'm gonna pay you. You've demanded the past due. I'm gonna give you $1,300. I'm gonna give you $7,000, and I'm gonna give you 1,300. They've satisfied 3 of your demands. But the remaining is the $40,000, a big amount.
Your Honor,
I mean, could somebody literally look at that and say, okay, I owe 4 separate amounts?
not legally, Your Honor. And I'll tell you why.
I understand that. Let's get away from the legally. Just from little reading, why, I guess what I'm asking is, why was it structured in such a way that it was segregated and made separate demands for each item? Maybe I'm not getting it here, Mr. Aguirre, and I'm frustrating you, but I gotta get it before I issue a notice here. My universe has shrunk into 2 letters, okay? My universe has shrunk to 2 letters, and this one and the other one. So I need to be clear on why you did it this way and what's the conventional wisdom of that, because it is confusing to me. I look at this and I look at a client and say, okay, well, God, all right, I mean, so you owe 40,000 on the principal amount and plus accrued interest on that amount. And then they also want 7,000 in reimbursement. All of them separately, you're entitled to demand. I agree with that because that's what the contract calls for, right?
Yes, sir.
But then I go back to what you told me earlier, that the 40,523.88 at that time was all of those amounts wrapped in one, including the $440 attorney's fees. Is that what I understood from you earlier?
Yes, Your Honor.
So if I eliminate this, added the insurance the unpaid installments, the unpaid taxes, and take it off of the principal amount, would that be a less amount?
Those amounts are principal and interest, Judge. The 4 past due installments are comprised of a certain amount of principal and a certain amount of interest. Okay?
Right, I get that. That one's easy.
The immediate reimbursement of ad valorem taxes, when a lender advances for taxes, that amount is automatically included in the principal amount. Same thing for forced placed insurance. When a lender advances money for insurance under the promissory note and the deed of trust, those amounts advanced are included as principal that are owed. So those amounts are termed taxes and insurance, but in reality, because we advance those amounts, those are included in the principal. They're not separate. They're not accounted for separately.
Why make why make demand for immediate payment of them separately?
Just to itemize the 40,000 amount, the taxes of 7664 were only for that year. They didn't include the previous years that were owed and already, incorporated in the principal.
Okay. All right, Mr. Nunez.
Your Honor, I feel like I'm beating a dead horse to a certain extent, but
You may be, and I may be helping you do that. So, please bear with me.
If you look at Exhibit 14, Your Honor, can I share screen that?
Hold on, let me.
Why is your demand of October? I guess this is where I'm confused, Mr. Zagira. Maybe this is part of beating the horse over the head on this whole thing. I'm confused by your lettering, by your demands. Why would the why was a demand of October the 8th not written in that same way? With segregation like the one you did in September?
I'm sorry, Your Honor, I don't have that one right in front of me.
I'll let you grab it. That's confusing to me too.
That one is actually a notice of foreclosure, Judge. The previous one was just a notice of default, letting them know that we're going to start moving for foreclosure if they don't bring in the amounts that are owed.
So what did you add to the foreclosure notice, October the 8th notice, that the amount of principal balance is different as stated in gross amounts? That's off by $400, $300. Why is it different? Because of the attorney fee that had been accumulated prior to, as per the letter of October September, where you said $440 currently in attorney's fee. Did you add that to the principal amount on October the 8th when you actually issued the notice of foreclosure, or what?
Your Honor, all of this is explained in detail in Exhibit D14. It's the letter, the demand letter that I sent to Mr. Nunez on behalf of his client. It's also very similar, almost identical to the letter brief that I filed with this court. On October 18th, we added, if you look at, the payoff statement.
What exhibit are you sending me to? Which one?
Exhibit D14.
D14.
It's a demand letter dated February 2nd.
Yeah, I got it right here. Hold on a second. Okay, I've got exhibit 14. This was written this year. In fact, 3 weeks ago. No, actually,
Last
a week ago.
Yes,
Is
sir.
that it?
Yes, sir.
All right. Now, what is it that you're pointing out to me?
So there's 3 documents that this letter references: a payoff statement from September 7th, a payoff statement from January 25th, and then a payment history. The payment history just reflects all the payments that the Ozuna's made and all of the advances for taxes and insurance that my client made. So just to clear up all the confusion, I go through and I say, look, this is what the principal balance was on such and such a date. Turn to page 5 of the history and you'll see that on August 18th, we advanced for insurance. And the 18th of each month just happens to be that the policy premiums are due. So you'll see a little payment for $94 and some change on each of those 18ths. So the principal balance is increasing every single month on the
I
8th
understand that, yes.
by those $94. So on October 18th, again, $94 got advanced. So the principal increased to $40,202.76. You keep on going month by month by month, and you get to January 24th, because remember, we haven't gotten to February 18th yet, but on the 18th, it'll increase another $94.
I understand that.
Currently, the principal balance is $40,485.93, and that is set in stone as far as the principal
Okay.
goes. Nothing changes that.
Let's talk about that. That's just, I think we're getting to where I'm confused and where my universe is shrinking.
Okay.
So in this year, what has happened from October of 2021 to February 2nd of 2022? What payments did you receive that drove the balance down from your demand that you made in October? In October, you demanded $40,723 as being the balance owed to you with all the things that we're talking about emerged. In February, you demand less, $40,485. What payment was given to you that brought down the balance from October of the year before to what it currently is in your latest letter? What payment was made that makes it come down? Do you understand me? Because if you look at your October 8th letter, which is the last letter that we're referring to, not September, now we're going with October. In October, you say your balance is $40,723.98 plus attorney's fees, interest, expenses, and whatever. Then in February, 3 months later, you give a different amount and it's less than that amount, and it should be more because you've accumulated more insurances, more interest, whatever, but it's less. What payment was given to you that makes it less?
3,700.
If you look,
I'm trying to calculate. I'm wondering if that was if that included interest.
I have no idea, so that's my inquiry, because in October 8th, you claimed $40,723.98. In January of this year, you claimed $40,485. It's less than the one you sent in October. So what payment was given to you that allows you to make it less?
I don't think it's less, Your Honor. I think one of them includes principal and interest, and the other one just includes the principal, if I'm not mistaken.
You claim in the letter of October, you say in October 18th, you advanced against another $94.39, which would increase the amount that you claimed in October letter. And then you claim that there are 3 more months of the principal balance being increased by $94, which would give you a much more amount, but yet your conclusion is $300 or $400 less than what was owed the year before in October.
Your Honor, this is Eric Wizian. If I can jump in here
Anytime.
and help Mr. Ezagite.
Are you part of the? Are you floating out in the universe like I seem to be?
No, Your Honor. The letter on October 8th states that principal plus unaccrued interest thereupon is $40,723.98.
Okay.
So the payment history that Mr. Ezagite is referring to is principal only. So that's where you're getting a difference in the number, Judge. It didn't go down. There weren't payments made
So why is the demand different?
because it's a demanding amount for the total due at that time, including
in
interest.
February or in October?
In October. The February is not a demand. It's actually a payment history, Your Honor.
So why did it become less? If you were always increasing, because he's not paying, he wasn't paying enforcing.
I'm sorry, Judge, where do you see that it went down? Because where do you see that it went down? Because the payment history keeps increasing. The actual principal balance has increased. You said where did it go down? But the payment history shows that it's gone up.
I only take it from your wording. So the principal balance as of January 24, 2022 is correctly accounted for at $40,485.93, right? That's what you claim in your letter of February 2nd.
That's the principal amount. Yes, Your Honor.
And you told me that the principal amount included all expenses, all fees, all costs. At least that's what you told me earlier, that Mr. Nunez was off base by adding all those amounts because they were all subsumed in the gross amount that you were claiming, the 40,723. So I'm still baffled why even talking about as correctly accounted for, it's less than what your demand was in October. It's confusing to me. And maybe you know, because you do this day in and day out and how it works and how you accumulate it. But still, we're not talking about us. We're talking about Mr. Osuna and Mrs. Osuna. What are they guided by and what amounts are they guided about? And I know that you guys know it like the back of your hand. Well, it's because this and this, but how does he know? It goes back to the confusion that was stated about earlier. If I got this 2 notice, I'm going, well, what the heck? And then again, Mr. Zaguirre jumps in and says, well, look, you didn't read further enough down to the paragraph. If you have any misgivings, you want an explanation, pick up the phone and call me and we'll give it to you. This is the Mother Hubbard clause he threw in there, you know, like, hey, if you have any questions, you want an accounting, you come and talk to me about it and I'll give you an explanation. Mr. Weissam, did you disappear?
No, Your Honor, I think he's still there, but my point is broader than that.
He's in default.
Yes, sir.
I know what the bottom line is that he's in default and Mr. Nunez, but the fact of the matter is that if he wanted to cure it, what does he cure?
I cited 2
And that's
cases.
the problem, Judge. And he's in default, Judge, if I can say 2 words here. He's in default, but he receives a notice of default, an opportunity to cure on September the 8th. And it tells him that he's behind $40,523 specifically in principal and interest. And he has each and every payment of the 48 payments of principal and interest. He has a receipt for it. And he knows that's not true. That's not the right amount. And then it's itemized that in addition to that $40,500 in principal and interest, he owes also $7,600 in taxes, that he owes $1,100 in insurance. It's itemized point by point. So he knows that that's not his default. That's not the amount that he owes. And when he adds those up, which anybody reading that letter would do, he comes up with $54,000. And he's saying, well, that's just not right. And that's why, to stop the November 2nd foreclosure, we had to file this suit to figure out what is right, what is owed, because it wasn't making sense to him. And that's the problem. And that's why this restraining order was proper. And that's why the injunction is proper, so that we can ferret this out, so that we can figure it out, so that the borrower we'll be able to figure out what he owes from information that we're eventually going to get from the lender, because there's too much contradiction here. I called it an accounting nightmare, and I was ridiculed by Mr. He's like, yeah, but I'm telling you, if the court can't figure it out, I promise you that Mr. Ozuna can't figure it out.
Ridicule is a strong word. I was being a little bit snarky, Your Honor, but what I would point the court's attention to is, and all due respect to both Your Honor and Mr. Nunez, none of this matters. The cases that I cited in my brief concerning confusion, Investors Realty Trust versus Carlton Corp. And the Ginther Davis opinion, both of them say, and I'm not stipulating this, I'm just saying for the sake of argument, let's say that the September 8th letter and the October 8th letter are irreconcilably confusing. And there's no way we can figure out from those two letters what the amount is owed. In the Investors Realty Trust case, they were moving for an injunction, trying to stop a foreclosure for exactly that same reason. Judge, we got these letters, these demand letters, and we couldn't figure out what was owed. There was just so much confusion going on there. Both the Investors Realty Trust and the Ginther Davis case both said, you know what, that doesn't matter. If there are amounts that are admittedly owed, the injunction is improper, the lender needs to go foreclose, and the debtor can continue suing for that accounting on the amounts that might be disputed. But there's no dispute. Even let's go a step further and take insurance out of the equation, because Mr. Nunez and the plaintiffs are disputing that the insurance is owed. Fine, let's forget about that as well. $30,000 in taxes are owed. No question about that. That amount needs to be tendered, or the lender needs to be allowed to foreclose. If the lender forecloses, the Ozunas still have their lawsuit pending. They can get all the accounting they need to make sure that upon foreclosure, the plaintiff's account was properly credited for the amount of the sale. If the lender then amends this lawsuit, not a suit on a note, but a suit for a deficiency, all that comes into play. But if the Ozunas want to continue suing us because they allege that they don't owe the insurance, or that we foreclosed on a debt that was $40,700 instead of a debt that was $40,500. They're more than welcome to do that. But the reality is the law says the lender needs to foreclose on the amounts that are undisputed, which are the taxes in the amount of $30,000. And if an accounting is necessary after the fact, so be it. One other point, Your Honor, in the Investors Realty Trust, the court made a point of noting, okay, even if these demand letters were confusing or they contradicted each other, during the litigation, after the plaintiffs had filed suit and got an injunction against a foreclosure, the defendant bank sent another demand letter that explained the actual amounts that were due, which is exactly what Exhibit D14 is. It's a letter dated February 2nd, after the lawsuit had already been filed, and it cleans up all of the accounting. There's no question about what is owed. So in those two cases I cited, the bank looks at the latest demand letter and says, okay, well, this clears it up. Let's forget about the other two letters that might have caused confusion. Again, we're not stipulating that they are confusing. We're just, saying for argument's sake that they are. The February 2nd letter clearly explains everything and gets rid of all the confusion. So in those two cases, the bank allowed the foreclosure to go forward, denied the injunction, and that's what we're asking the court to do.
I haven't read that case. When did you file that one?
Again, Your Honor, I apologize. That's the one I filed yesterday.
Okay, well, because I have no reference to do it. Ms. Salas, do I have it?
We gave you everything, Judge,
Case that was filed.
everything that was filed.
Okay, so.
Judge, my point is that the law also requires a notice of default and opportunity to cure. That's why that notice is sent. So we have a notice of default that's incorrect, that's contradicted.
No, not the February 2nd one.
September contradicts October, October contradicts September.
I'm wondering, why is the balance going down if there is no payment being made?
All of that was cleared up Your Honor,
Because in your February 2nd letter, you claim 40,485, which we already talked about. But then you come back on February 7th in 2022 and you issue another letter explaining everything. And in that one, you conclude that it's $40,108, even less than the September 2nd, the February 2nd letter. A week later, you write another letter that has a different amount, and it's even $300 less than your conclusion in February 2nd of this year. A week later, your conclusion is $40,108. How is the balance coming down? I guess is what I'm confused here.
Your Honor, the February 7th letter does not.
Whether it's irrelevant or not relevant. I'd like to know, why is it coming down? What is reflecting? How is it coming down?
The February 7th letter does not come down, Your Honor. It says the exact same amount, 40,485 and 93 cents. It's at the top of page 2. Second line up from the bottom of the first paragraph there. And it cites both attachment 2 and attachment 3 to this particular letter. The attachments to these letters illustrate everything, Judge. It's the payment history.
You're right. You're right. I didn't read the other paragraph. It's the same amount on the top of the paragraph.
Yes, sir.
I don't have that case, Ms. Salas. You gave me a whole bunch of stuff. I don't have that case.
You don't have that one?
Well, hold on a second. It's in the brief concerning debt balance, right, Mr. Izaguirre?
Yes, sir.
All right. Can you give me a second? I haven't seen this, so. Anything else? Council, anything else?
I'm sorry, Your Honor. No, I was just looking at the accounting. The payoff
Anything else? Mr. Nunez, you're muted.
Sorry, Judge, I was muted. Nothing else.
Mr. Aguirre.
No, Your Honor.
All right, let me carefully look at the case that I had not read. I read a little part of it, and I'll have a decision for you later today.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honor.
And now my universe comes into the confusion of paper. Okay, you'll have a good day.
Thank you, Your Honor. You too.
Bye.
Estela, do you have anything for tomorrow?
Yes, I sent you my list already. Did you get it?
Send it.
Did you get it?
Oh, when did you send it?
This morning. Let me look at my.
Yes, I got it. I got it.
Okay, good.
I got it.
Good. Okay.
Okay.